Hello! Welcome again! So today, we will continue our discussion about payment or dun nga sa extinguishment of obligation, yung part 2 ng payment or performance. So, before nag-end tayo with Article 1239, so ngayon, let's start with Article 1240 up to 1251. Tapusin na natin. Okay, so Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. So, obviously, this question or this provision answer the questions to whom payment must be made. Kanino ba dapat ibigay yung payment? Okay? Ang sabi ni Article 1240, in whose favor the obligation has been constituted. Meaning, kay obligee or, kay obligee or kay creditor. Tapos, take note, it refers to the creditor pala at the time of the payment. Okay? Not necessarily na siya yung creditor at the constitution of the obligation. So, kung halimbawa, meron ng bagong tao who has been subrogated to the right of that creditor, so dun na sa kay new person or yung third person who has been subrogated to the rights of that original creditor. So, sa kanya mo na ibibigay yung payment. Okay? Second, his successor in interest. Sino ba sila? Either yung heirs or yung assignee. Tapos yung third, or any person authorized to receive it. So, the phrase means not only a person authorized by the creditor, okay? But also a person authorized by law. Okay? Pag sinabing any person authorized to receive it, hindi lang siya nagre-refer sa taong inauthorized ni creditor to receive, but also a person na inauthorized ng batas to receive such payment. Like, sino ba? Yung mga guardian, yung mga administrator or executor ng estate ng deceased person, yung assignee or liquidator of a partnership or corporation. Yan, yun yung mga taong authorized by law to receive payment. Okay? So, please take note also, kapag ang pagbabayad ay ginawa sa maling tao, okay, hindi dito sa tatlo. Hindi kay creditor, not in his successor in interest, hindi rin sa taong inauthorized to receive payment. So, to the wrong person nga yung payment ginawa. So, obviously, pag ganon, the obligation is not extinguished. So, dapat is yung paying dator must not just pay, but must properly pay. Paano ba? Kasi hindi, kahit pa si debtor acted in at most good faith, it is not an excuse for a wrong payment. Okay? Yung obligation is still not extinguished pag ganon. At dahil hindi na extinguished, siya ay meron pa ring obligation to pay, right? But this rule is not without prejudice, or it's without prejudice to Article 1241. Why? Ano nga ba ang sabi ni Article 1241? Okay, so basahin na natin. Proceed tayo kay 1241 muna. Sabi ni 1241, payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. Number 1, if after the payment the third person acquires the creditor's rights. 2, if the creditor ratifies the payment to third person. 3, if by the creditor's conduct the debtor has been led to believe that the third person had authority to receive the payment. So this provision talks about payment to incapacitated or unauthorized person. Yung first paragraph talks about payment to incapacitated. Tapos yung sa second naman, it's about payment to unauthorized person. So yung first paragraph, payment to incapacitated person, ang unahin natin i-discuss, obviously. So question, is the payment to a person who is incapacitated to administer his property valid? Ang sabi ni first paragraph ng Article 1241, it is valid only, number 1, if the incapacitated person has kept the thing delivered. And second, insofar as the payment has been beneficial to him. So, halimbawa, ganito. Pogi owes Ganda 1 million pesos. Nung babayaran na sana ni Pogi si Ganda, abay, baliw na pala si Ganda. He is not in a sound mind anymore. She was already insane nga. So, however, the money was never spent and it is still in the possession of Ganda. Okay? So, the magic question, is the obligation extinguished? So, ang sagot, yes. Kahit pa si Ganda ay naging incapacitated to administer her property, pero, take note, she has kept the thing delivered. Right? So, meaning the payment is valid. Sino ang may sabi? Si Article 1241 ng first paragraph. Okay? Now, supposed, merong manluloko, fraudulent or swindler, estapador, hiningan si Ganda ng 1 million pesos in exchange for a ring worth 500,000 pesos lang sana. So, naloko si Ganda. Now, does the payment remain to be valid? Yung payment ba ni Pogi na 1 million pesos kay Ganda? Tapos later on is may estapador na nanloko kay Ganda? Does that 1 million peso still valid? Does that 1 million peso payment of Pogi remains to be valid? Yung payment ay valid pa rin, but only up to an amount of 500,000 pesos. Dahil ito lang yung amount which Ganda was really benefited from Pogi's payment. Okay? Yun yung karugtong insofar as the payment has redounded to the benefit of the creditor or the incapacitated person. So, another question. Who has the burden of proving that the payment was or has benefited the incapacitated payee? Answer. The one who made the payment. Okay? The debtor has the burden of proving that the payment benefited the incapacitated payee. Ano ba ang example ng beneficial payment? Kailan mo masasabi na yung payment benefited the incapacitated payee? Hindi naman kailangan ng mga proof of investment and the like. Hindi naman talaga yung ganun. Okay? Not to that extent. What the law requires is that the payment has redounded to the benefit of the incapacitated payee. So, example, if yung bayad ay nagamit sa hospital for hospital expenses ng pagpapagamot ng incapacitated payee. In our example, if si Ganda, nagamit niya yun pang bayad dahil sa kanyang psychiatrist para gumaling siya sa kanyang pagiging baliw. Okay? So, it is considered as the payment has redounded to the benefit of the incapacitated payee. Okay? Now, paano if yung bayad ay hindi nag-redound into the benefit of the incapacitated payee? So, halimbawa, yung bayad ni Pogi na 1 million pesos ay actually nawala lahat. Dahil nga, wala naman sa sound mind si Ganda. It's as simple as yung payment is not valid. Thus, so kung ano yung epekto pag hindi valid yung payment? In this example, si Ganda if gumaling na siya, pwede niya pang singilin ulit si Pogi ng 1 million pesos. Or kahit yung legal representative ni Ganda, kahit hindi siya gumaling, pwede rin yung legal representative or yung guardian ni Ganda, pwede niyang singilin ulit si Pogi ng 1 million pesos. Okay? I think malinaw na yan. So, dito tayo sa second paragraph. Payment to a third party not duly authorized. Actually, same rule. It is valid insofar as it has redounded to the benefit of the creditor. Okay? Ganun pa rin dun sa incapacitated person. And as a rule, yung bayad, it is not presumed. Hence, dapat i-prove. I-prove na dapat, na yung payment has benefited the creditor. Okay? Tapos, yung second paragraph, nag-provide siya ng 3 instances kung saan hindi na kailangan yung benefit ay hindi na kailangang i-prove. So, valid na siya. Okay? Yung payment. First, if after the payment daw, the third person acquires the creditor's rights. So, example, if merong impostor agent, tapos sa kanya ka nagbabayad, without knowing na hindi pala siya yung totoong or authorized agent to receive that payment. Pero later on, yung impostor agent has become the owner of that company. So, na-acquire niya rin naman yung rights. So, in that case, the payment is valid. The third person acquires the creditor's rights. Yun yung ibig sabihin niya. Tapos, yung second scenario, if the creditor ratifies the payment to the third person. Example ulit, if yung collector nyo para maningil ng kuryente is unauthorized pa rin. Pero, after nyo namang magbayad, ini-inform kayo ng company na okay na yung bayad niya, ng bayad nyo, and yung payment na yun is alright, okay lang. So, parang na-ratify rin nung electric company yung payment nyo. Right? Tapos, third, if the creditor's conduct, the debtor has been led to make the payment. Like, yun pa rin, si collector na unauthorized. Ba't naman kasi binibigyan siya ng company ng uniform for its collectors? So, dahil dun, you've been led to make the payment to that person. Kasi nakasuot siya ng uniform. Yung totoo pala, hindi pala dapat siya authorized agent ng company. So, dahil dun, dahil you have been led to make the payment, dahil din sa kay creditor or yung sa company's conduct mismo, so, valid na rin yung payment mo. Okay? So, punta na tayo kay 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. So, payment made in good faith to a person in possession of a credit. So, this is another situation ng valid payment. Dito, mayroong 2 requisites. Payment by the debtor must be in good faith, and the payee must be in possession of the credit itself. Meaning, possession of the credit. Hindi necessarily yung possession ng document evidencing that credit. So, example, if si Pogi found a negotiable instrument payable to bearer. Tapos, dahil dito, yung maker ng negotiable instrument, supposing it's a promissory note, so binayaran niya ngayon si Pogi kasi nga payable to bearer naman yung promissory note na yon. So, at in good faith siya. Right? Hindi ba? So, yung payment na ni maker extinguishes the obligation even if Pogi was not entitled to the promissory note. Pero had it been na yung promissory note was payable to a specific person, okay, yung nakalagay sa promissory note ay may specific person talaga na payable to Beauty. At hindi yung payable to bearer lang, so kung sino yung may hawak. So, dahil payable to Beauty siya, then the payment to Pogi was not valid. Dahil pag ganito, si Pogi is just a possessor of the document. hindi ng credit mismo. Unlike dun if yung sa scenario na possessor siya nung bearer instrument talaga. Okay? It's as simple as that. Now, Article 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. So, this provision discusses about the payment made after judicial order to retain. Okay, to retain the debt. So, itong judicial order, it may have been prompted by an order for like attachment, injunction, or garnishment. For this discussion, sa 1243, let me discuss yung sa garnishment. Naalala nyo yung rule na the debtor of my debtor is my debtor? Medyo somehow connected siya doon. It's like this. Sa garnishment, yung debtor of a debtor is ordered not to pay muna so that preference can be given sa kanyang creditor. Gets nyo ba? Or mas magulo sa sinabi ko? Well, actually, mas maiintindihan siya using an example. Ganito na lang. Pogi owes, okay, may utang siya kay Ganda na 1 million pesos. Tapos, ito namang si Ganda ay may utang rin. So, debtor din siya ni Beauty na 1 million pesos. So, ganito ang nangyari. Si Beauty ay nag-file ng action against Ganda para masingil ang 1 million pesos. Pero si Ganda claims insolvency. Hindi niya na daw kayang bayaran. At wala talaga siyang pangbayad. Pero inamin niya rin naman na si Pogi ay may utang sa kanya na 1 million pesos. So bago pa man magbayad si Pogi kay Ganda ng 1 million pesos kasi nga may utang siya kay Ganda, Pogi was summoned into the proceeding doon sa court hearing and was asked by the court to retain the money or the debt in the meantime, meaning the debt is garnished. During that time, pending yung decision, kasi i-determine pa sa court if may utang ba talaga si Ganda kay Beauty, any payment during that pending yung determination pa ng court, any payment na gagawin ni Pogi kay Ganda is invalid. Yan yung sinasabi ni Article 1242. So that's it. Malinaw ba? Ganun rin naman yung concept if halimbawa the case was interpleader or yung sa injunction. May judicial order na the court prohibiting payment or i-retain muna yung bayad kasi may hearing pa na nangyayari dito, may court proceedings pa na pending. Tapos, despite that order, nagbayad si debtor. So, yung payment ng debtor na yon doon sa kay creditor is invalid. Okay, that's Article 1243. Now, Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be one of the same value or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obliged will. So yes, this is as simple as the rule na yung mismong prestation mismo, yun yung dapat ibigay as payment para ma-extinguish ang obligation. So first paragraph refers to a real obligation to deliver a specific thing. Yung second naman about personal obligation, yung to do and not to do. So malinaw and I think very self-explanatory ang provisions na to. Si debtor cannot compel the creditor to accept different object kahit pa mas mahal pa yung ipapalit niya, okay? Pero meron din naman tong exceptions. This rule is not absolute. Yung exceptions dito, number 1, in case of facultative obligation. Di ba? Pwede yung substitute ang ibigay. Tapos, nasabi ko na rin yata sa previous video, sa part 1 ng discussions about payment, Pwede yung decision in payment, that is Article 1245, which we will discuss shortly after this provision. Tapos yung novation when we reach Article 1291. Ito yung mga instances na yung ibibigay mo ay hindi yung mismong napag-usapan. Okay? Tapos, another exceptions din pala is in case pag may waiver ng creditor, so either expressly or impliedly. Kung tinanggap siya as payment, di ba? Kahit iba yung object na binayad, okay lang naman dun sa hindi nagreklamo. So, pwede yun. But he cannot be compelled if ayaw niya. Okay? That's Article 1244. Now, Article 1245. Dasion in payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. So, ito yung sinabi ko kanina. At last, maiintindihan na rin natin siya. So, what is dasion in payment ba? It is actually a special form of payment. It is a mode of extinguishment of an obligation whereby yung ibibigay ni debtor is property in order to satisfy the money or the monetary debt. Okay? Yung obligation niya is monetary. Pero yung ibabayad niya is yung property niya. So, example, if si Pogi may utang kay Ganda na 1 million pesos and yet, yung ibabayad niya with the consent of Ganda naman is yung bahay niya. Hindi pera na 1 million pesos kasi wala siyang 1 million. Okay? Ang sabi ni Article 1245, it shall be governed by the law of sales. Kasi, obviously, it actually partakes, in a sense, yung nature ng sale, right? It's like as if si creditor is buying the property of the debtor at ang bayad ay ang utang niya, di ba? And since governed siya ng rule ng sales, meaning the conveyance must be deemed to extinguish the obligation to the extent only of the value of the property. So, as agreed or as may be proved. Unless yung parties have considered the property as dun sa agreement nila mismo, expressed or implied, pwede rin, na yung property is full payment na siya. In which case, yung obligation ni Pogi ay extinguished na. Kasi halimbawa, kung yung bahay niya is worth 800,000 pesos lang, tapos 1 million yung utang niya kay Ganda, in that case, meron pa siyang utang na 200,000 pesos supposedly. Pero kung may agreement naman sila na okay na, yung bahay will be considered as full payment na nung obligation ni Pogi, then pwede rin naman. Okay? Now, let's distinguish from dasion in payment, sales from dasion in payment. Sa sale, there is no pre-existing credit. Tapos, kay dasion in payment, there is pre-existing credit. Kung sa sales, obligations are created. Pag bumili ka, di ba? Doon pa lang makikreate yung obligation. Kay dasion in payment, yung obligation ay ma-extinguished. Tapos, sa sale, the cost is the price paid from the viewpoint of the seller or the acquisition of the thing sold from the viewpoint of the buyer. Pero kay dasion in payment, the extinguishment of the debt from the viewpoint of the debtor, tapos yung acquisition naman ng object in lieu of that credit, yun yung cost from the viewpoint of the creditor. Tapos, kay sale, si buyer has still to pay the price. Babayaran niya pa lang yung binili niya. Pero kay dasion in payment, na-receive niya na yung payment before pa yung contract. Kasi nga, it is charged against dun sa utang ni debtor. Tapos, the parties deliver and receive the thing as seller and buyer dun kay sale. Pero sa dasion in payment, as debtor and creditor. And lastly, the giving of the price may generally end the obligation doon sa sale. Kasi nagbentahan, nung nagbayad ka na, tapos na. Tapos kay dasion in payment, yung pagbigay mo ng credit may extinguish completely or partially yung credit. Depende kung ano yung nasa agreement. Yun nga yung sa example natin kanina, like kung yung bahay is 800,000 pesos tapos yung utang is 1 million, so either completely or partially lang yung mai-extinguish na obligation. Okay? That's it. Let's proceed to Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing, whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Actually, na-discuss na rin naman natin to somehow. Naalala nyo pa yung sa first part ng nature and effects ng obligation? Dun sa, di ba nag-discuss tayo pag obligation to give a specific thing, tapos in-insert din natin yung obligation to give a generic thing. So, this rule or this law, these particular provisions is also called the rule of medium quality. Bakit? Kasi ganito yan. Unlike if dun sa obligation to give or to deliver a specific thing, di ba doon is yung the very thing due, kung ano yung napag-usapan, yun mismo ang i-deliver, yun mismo ang ibibigay. Pero, dito, kasi nga generic, so, ano yung ibibigay mo? Wala namang specific thing na ibibigay. Ang sabi, when the obligation consists in the delivery of an indeterminate or generic thing, whose quality and circumstances have not been stated. First, sa creditor raw, he cannot demand a thing of superior quality. So, if okay lang sa kanya, pwede siyang mag-accept ng inferior quality kung okay sa kanya. Pero hindi siya pwedeng mag-demand ng superior quality. Tapos, etong si debtor, hindi naman siya pwedeng mag-deliver ng inferior quality. Pero if okay lang din sa kanya, pwede rin siyang mag-deliver ng superior quality. Right? So, the rule of medium quality. Yun. So, please note nga rin pala, this article talks about quality and other circumstance na hindi na state. Hindi quantity or kind ang na hindi pa na-determine, okay? Kasi pag hindi nyo pa na-determine kung yung quantity at saka yung kind ng object na i-deliver, wala. Tapos kailangan nyo talaga ng new contract in order to determine the quantity and the kind ng object na i-deliver. Then, meaning that contract is void. Dahil kailangan nyo pang mag-execute ng bagong kontrata. And note din pala sa last sentence, the purpose of the obligation and other circumstances shall be taken into consideration. Okay? In determining kung ano nga bang quality ang ibibigay. Since hindi naka-state doon sa kontrata nyo. Yung quality lang ha, hindi yung quantity at saka yung kind. Now, let's proceed to Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to the judicial cost, the rules of court shall govern. Simplify na rin natin. Madali lang naman tong provisions. Okay? Madali lang tong provision na to. Sinasabi niya lang na si debtor ang may obligasyon to pay for extrajudicial expenses. Unless may stipulation na si creditor ang magbabayad ng mga extrajudicial expenses for the payment. Okay? If wala sa agreement kung sino ang magbabayad ng extrajudicial expenses required by the payment, then si debtor ang magbabayad. Why? Bakit? Because it is provided under Article 1247. At yun yung sabi ng batas. Okay? And the reason for this is dahil siya naman kasi yung magbi-benefit. Dahil pag na-execute or na-perfect yung payment, after all, yung obligation niya yung mai-extinguish. Okay? Now, meron ding sinasabi dyan about the judicial cost. Well, nasa discretion na rin naman yan ng court. Yun lang ang ibig sabihin yan. Okay? It's as simple as that. Let's proceed to Article 1248. So, unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestation in which the obligation consists, neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Okay, so balikan na naman natin tong general rule. Payment must be complete. Hindi pwedeng partial. Actually, alam nyo na yan, pabalik-balik siya. And so, ang mas magandang pag-usapan ay ang exceptions. These provisions provide for another exception to that rule. So, kailan ba or anong situation ba allowed ang partial payment or partial performance? So, first, when there is a stipulation to that effect. Diba? Kung nasa usapan nyo naman na partial, okay lang, partial yung payment. Then, why not? Naalala nyo yung example natin before, yung may iba't ibang condition, like yung payment kay ay babayaran ko si Luis ng 1 million pesos if pumasa siya ng bar, tapos yung kay Bella is ganito, ganyan. Diba? So, pag ganun, depende kung anong mga condition yung naganap na, then dun mo lang din. So, magkakaroon talaga siya ng partial performance or partial payments. Now, this provision, si 1248, provides for another exception. Yun daw is pag yung debt is in part liquidated and in part unliquidated. So, sabi, the creditor may demand and the debtor may effect the payment without waiting for the liquidation of the latter. Okay? So, example, ganito. Pogi owes Ganda 1 million peso due today. And so, dahil ngayon yung due date ng utang niya kay Ganda na 1 million peso, si Pogi hindi niya pwedeng i-compel si Ganda to receive 500,000 pesos lang. So, parang partial payment to the obligation. And on the other side, si Ganda hindi niya rin pwedeng i-compel si Pogi na 500,000 pesos muna yung bayaran. Wag muna niyang i-fully paid. Yun yung paragraph number 1. Diba? Basahin nyo. Yan yung sinasabi niya. Tapos, unless nga naman may agreement to the contrary na nakalagay na pwede sa kanila yung mga partial at partial performance. Now, if ganito yung nangyari, if Pogi owes Ganda 1 million pesos plus damages, and kahit na, for now, hindi pa na-determine kung magkano ang exact amount ng damages na babayaran ni Pogi. Pero yung utang niya na 1 million pesos is already known and liquidated and it is already due. So, dahil ganon, Ganda may demand and Pogi may pay the 1 million pesos which is already known. Tapos, later on na lang yung sa kung magkano yung amount ng damages na babayaran supposedly ni Pogi kasi unliquidated pa yun. Hindi pa alam kung magkano talaga. Okay? That's the meaning of the second paragraph ng Article 1248. So, let's proceed to Article 1249. Alam niyo ba yung legal tender? What is legal tender? Accordingly, legal tender is the currency which a debtor can legally compel a creditor to accept in payment of a debt in money when tendered by the debtor in the right amount. Yun. Yung currency na si debtor pwede niyang i-compel si creditor to accept pag nagbayad siya. Okay? As to BSP Circular number 537 series of 2006, ang sabi, coins in the denomination of 1 peso, 5 peso, and 10 pesos shall be the legal tender in an amount of not exceeding 1,000 pesos. So, dapat hanggang doon lang. Pag more than that na, hindi ka pwedeng magbayad ng 5,000 pesos worth tapos tagpa-peso, 1 peso lahat. Kasi yung legal tender is 1,000 pesos. So, hindi mo na pwedeng ma-compel si creditor to accept that amount. Pero kung a-accept niya, then why not? Tapos, yung coins in denominations naman daw na 1 cent, 10 cents, or 25 cents, yung legal tender niya is an amount not exceeding 100 pesos. So, up to that amount lang. More than that, hindi mo na pwedeng i-compel si creditor na tanggapin yung bayad mo na worth 500 pesos tapos tagwa 1 peso. Okay? Hindi mo siya pwedeng i-compel. Pero pag tinanggap niya, okay, ganon. Tapos, simplified lang natin ng provisions na to. Yung first paragraph muna, ang sabi niya, under first paragraph, payment may be either in currency stipulated, so kung ano yung napag-usapang currency. Tapos second, if it is not possible to deliver such currency, the Philippine legal tender. Yun yung sabi. However, this provision was already repealed by Republic Act 529. Kasi doon sa RA 529, pinrohibit yung stipulations ng currency other than Philippine currency. So, meaning, hindi na pwede yung ibang or yung mga foreign currency. Philippine currency na lang at that time. Pero, ngayon, later on din naman, lumabas rin si RA 8183, which is nirepeal niya din naman si RA 529. So, meaning, as of ngayon, obligations or transactions may now be paid in currency agreed upon by the parties. Not necessarily Philippine currency na lang. Okay? Yun lang yun. Huwag na nating pahirapan. Ang haba kasi ng discussion dyan. Anyway, yun lang yung meaning niya. Tapos, si second paragraph na tayo. Sabi, the delivery of a promissory notes payable to order or yung mga bill of exchange or yung mercantile documents. Kasama na rin dito yung check kasi negotiable instrument din naman yung check, di ba? Tapos, sabi, shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. Actually, itong mga mercantile documents and like check, they are not a legal tender. And so, yung creditor cannot be compelled to accept payment through this. Kung yung babayaran mo siya ng promissory note or ng check, hindi mo siya makakompel kasi hindi siya legal tender. So, eto na lang. Let's give an example to better understand this second paragraph. Eto, Pogi owes Ganda 10,000 pesos, payable on December 25, 2020. So, si Pogi is paying a promissory note of 10,000 pesos. Question, can Ganda refuse to accept? Number 2, can she accept? Number 3, if she accepts, does this mean that payment has been effected? So, let's answer. Yung number 1, can Ganda refuse to accept? Yes, because it is not a legal tender. And so, the creditor cannot be compelled to accept payment through these means. Okay? Second question, can she accept? Yes, that is her option. Option yun. Pwede rin naman. Now, 3, if she accepts, does this mean that payment has been effected? Not yet. Sabi nga, it shall produce the effect of payment only when they have been cashed. Diba? Yun yung sabi nung batas. Now, suppose, si Ganda ay pumayag naman, okay, may consent from her end na yung bayad ni Pogi is promissory note, tapos payable in 2 months pa later. Now, during that intervening period, during that, yung time na nag-promise, tapos pumayag siya, bago pa yung 2 months dumating, kasi payable within 2 months. Ang tanong, May Ganda bring an action to recover from Pogi? Kasi hindi na siya makapaghintay. Pumayag siya pero gusto niya nang mag-ano ngayon, singilin na talaga. Ang sagot, no. Kasi nga sabi ng last paragraph ng Article 1249, pending the encashing of the mercantile documents, the action derived from the original obligation shall be held in abeyance. So, naka-held in abeyance pa siya. Okay? That's it. Malinaw na siguro. Okay? Hopefully, naliliwanagan. Last two provisions before we end this discussion at makati na ang aking lalamunan. Anyway, Article 1250. In case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement to the contrary. So, let's define muna yung mga terms. Nagsabi siya ng inflation and deflation. Pag inflation, ito yung definition daw. It is a sharp, sudden increase of money or credit or both without corresponding increase in business transaction. So, meaning, pag inflation, it causes the drop in the value of money. So, resulting naman in the rise of the general price level. Okay? Biglang magda-drop yung value ng money. Kasi may sudden, sharp increase of money or credit and walang corresponding increase dun sa business transaction. Now, pag deflation, ito naman is yung reduction in volume and circulation of the available money or credit. I think alam nyo pala to kasi mga commerce-related ata yung courses na nanonood dito. Well, anyway, basta yung deflation is the opposite of inflation. Meron dalawang requisites para sa provisions na to. Number 1, there is an official declaration of extraordinary inflation or deflation from the Bangko Sentral ng Pilipinas. Tapos, second, the obligation is contractual in nature. Okay? Kasi 'di ba, pag binasa mo, doon sabi extraordinary inflation or deflation of the currency stipulated. So, dahil may stipulations, malamang it talks about contracts. Okay? So, Article 1250 is applicable only to case where a contract or agreement is involved. So, more importantly, the parties must agree to recognize the effects of extraordinary inflation or deflation. So, at present, the inflation in the Philippines is only ordinary and not extraordinary. So, if it becomes extraordinary, the basis of the payment is the value of the currency at the time the obligation is constituted. Yan yung sabi ni Article 1250. Okay? And not yung, hindi yung value ng currency at the time of payment. Okay? That's it. So, let's proceed to Article 1251. So, etong provision na to talks about the place where the obligation shall be paid. Saan ba daw babayaran? First rule, if there is a stipulation, then kung saan yung stipulation, anong sinasabi doon? 'Di ba? Kung at the place designated, kung saan nang napag-usapan na doon ang bayad. Now, if walang stipulation, then we have to classify if it is a delivery of a specific or determinate thing. Pag specific thing, sabi, payment shall be made at the place where the thing was at the time of the perfection. So, kung nasaan nakalagay yung specific thing at the time ng perfection. And second, if pag yung obligation is consist of the delivery of indeterminate or generic thing, sabi yung delivery or payment must be made at the domicile of the debtor. And pag si debtor daw, nag-iba ng domicile in bad faith or after nagka-incur na siya in delay, meaning nagkaroon na ng legal delay or default, yung additional expenses ay kanyang ibibear. Siya yung magbabayad doon sa additional expenses in going to that place para masingil or magbayad siya. At ang sabi ng last sentence, these provisions are without prejudice to the venue under the rules of court. Ito naman is more on yung sa filing of case kung saan. Okay, yung venue, it is actually the place where a court action or a court suit must be filed or instituted. Okay, that's it. Thank you for watching until the end. See you in our next video.